Ladies, gentlemen, or the one person who may be here on their own of either sex, that's not an issue. My name is Paul Graham. My business name is Irish Paul, as in Irish Paul Firearms Training. I'm dressed today as I once would have been dressed back when I was a detective, with a shirt and tie, reasonably formal in this part of the world. This is also the way a lawyer would dress. A big part of the course is North Carolina state law in connection with the use of force and concealed carry. And a big part of the course is that if you fall foul of that law through ignorance or bad judgment, you will wind up speaking to either a detective or a lawyer who will be acting on your behalf. And when that happens, you want to make sure that you have made a well-informed decision, that you knew what the relevant law was, and therefore this next session is one where I would ask you to open up your book, follow along with me, and I'm going to read the relevant passages. And I've put this on video for two reasons. One is for consistency, so that in the event of a legal dispute at some point in a few years' time, if they refer back to the training that you received, I will be able to stand with hand on my heart and say, I taught the law exactly as laid out in the handbook that was handed down by the North Carolina Criminal Justice Department. So, word for word, I'm going to go through it. I'm going to try and read slowly and clearly enough that, in spite of my accent, I am still speaking English. So in spite of my accent, hopefully you will be able to understand. And I'll try not to go too fast, and we will get through this. It's an 8-hour course, and there's a reason for that. There's quite a lot to cover, and the biggest part of that is the law. So without further ado, let's make a start. Lesson 1, legal issues. North Carolina common law. Use of force to protect a person. 1. Justified self-defense. A citizen is legally justified in using deadly force against another if and only if 1. The citizen actually believes deadly force is necessary to prevent an imminent threat of death, great bodily harm, or sexual assault, and 2. The facts and circumstances prompting that belief would cause a person of ordinary firmness to believe deadly force was necessary to prevent an imminent threat of death, great bodily harm, or sexual assault, and 3. The citizen using deadly force was not an instigator or aggressor who voluntarily provoked, entered, or continued the conflict leading to deadly force, and 4. Force used was not excessive, greater than reasonably needed to overcome the threat posed by a hostile aggressor. There's a lot of information in that one passage, the bar for justified self-defense. So basically, if 2 shots would have been enough to stop the threat, and you put a further 16 into the person, you're going to have to justify and explain why you did that. So it's all about balance and what a person of reasonable firmness would think was necessary in the circumstances, and that could vary depending on the jury panel, the area you live, and everything else. So justified self-defense has to be justified, it has to be to prevent an imminent threat of death, great bodily harm, or sexual assault. And the facts and circumstances, that's the totality of the circumstances, need to be such that deadly force is justified. Retreat. A citizen faced with an imminent threat of death or great bodily injury generally does not have a duty to retreat prior to using deadly force, when all the other elements of self-defense are satisfied. Regardless, it may be advisable for a citizen to retreat to safety, if feasible, as this may not only avoid the use of deadly force, but may also remove the citizen from a situation that could result in the loss of their own life. However, a duty to retreat does exist where the citizen was the initial aggressor or instigator in the incident that caused him to eventually use deadly force in self-defense. If the aggressor completely withdraws from this confrontation and clearly communicates this to his adversary, the right to use deadly force in self-defense is restored if all the requirements for the use of deadly force in self-defense are still met. That's from John Rubin, The Law of Self-Defense in North Carolina, UNC Chapel Hill, 1996. So what does that mean in practical terms? Well, a situation that would spring to mind perhaps would be a road rage incident. If you're offended by someone's driving and you call them out on it and it causes a situation and they maybe pull a knife or threaten to beat you up or whatever, you started the situation because you called them out over their driving, so you took it from being a driving incident to being a potential assault. That puts the onus on you to try and step back and defuse the situation, and if the person comes after you with a knife, when you have tried to step back, when you have tried to retreat, your right to use self-defense is restored. That's how I would read it, and that's how I would try to put it in a practical context. But it is well worth remembering that it's probably not a good idea, especially when you're carrying a gun, to provoke a situation that could lead to a force encounter. Sometimes discretion is the better part of valor, and you should just record details for future report to law enforcement. But these are matters we'll go into some detail maybe later. Imminent harm means immediate danger or is about to happen. Great bodily harm is not defined. However, the statutory definition of serious bodily injury contained in the North Carolina criminal law provides guidance as to the type of injuries that may qualify as great bodily harm. Serious bodily injury includes injury that creates a substantial risk of death or serious permanent disfigurement, coma, a permanent or protracted condition that causes extreme pain, or permanent or prolonged loss or impairment of the function of any bodily member or organ, or that results in prolonged hospitalization. So that's a lot of legalese, but if someone says they are going to beat the living heck out of you, I think you can anticipate that one of those outcomes is potentially going to happen. A sexual assault would include rape, sexual offence, or forcible crime against nature, or attempts to do any such act. Not all sexual assaults justify the use of deadly force. Much of the law on justified self-defense in North Carolina was written before the legislature redefined sexual offenses in this state. Basically, there are two categories of sexual offense. One is rape, and two, sexual assaults. Therefore, if it is not rape, it is sexual assault. Many sexual offences do not meet the standard for inclusion in the justified self-defense formula. Only sexual assaults that have a risk of death or great bodily harm should be included. Now, just to clarify on that, if a person comes up and pinches a woman's backside, which was a pretty significant hazard back in the day, particularly in certain parts of the world, that may be an assault that's sexual in nature, but that would not justify the use of deadly force. It has to be something of a really egregious nature, assault with intent to commit rape, or something of that kind. Excessive force. A citizen has the right in self-defence to use only such force as reasonably appeared necessary under the circumstances to protect themselves from death or great bodily harm. In determining the amount of force necessary, and in order to avoid excessive force, the citizen should consider the size, age and strength of the citizen as compared to the attacker, the fierceness of the assault, if any, upon the citizen, whether the attacker possessed a weapon, and the reputation of the attacker for danger and violence, or any other circumstance relevant to this issue. The one that would kind of spring to mind there is the videos that emerged of Michael Brown, who was shot in Ferguson. When you looked at the size of him, he was able to do strong arm robberies just by the force of his personality. So if you're up against someone who physically is capable of beating you to death and perhaps has a reputation for that kind of behaviour, it's easier for you to justify the use of deadly force than if you're up against some 90-pound weakling who is unlikely to be capable of inflicting that degree of harm on you. So that's where common sense and circumstance kind of plays into it. Aggressor. A citizen who is found to be an aggressor, voluntarily provoking the conflict, or who used excessive force, can be convicted of voluntary manslaughter, even though the use of deadly force complied with the other requirements of self-defence. An instigator, or person using excessive force, is not excused from all criminal liability, but may be guilty of a lesser degree of homicide. So you may not be prosecuted for murder in the first degree, but you may go down for manslaughter, and either way you're probably looking at serious jail time. Don't let that be you. A citizen who is an aggressor, voluntarily provoking a conflict leading to deadly force, can avoid criminal responsibility for deadly force only if the aggressor attempts to withdraw from the conflict before using deadly force and gives notice of withdrawal to the adversary. Quotation marks. One enters a fight voluntarily if one uses towards one's opponent abusive language which, considering all of the circumstances, is calculated and intended to bring on a fight. A citizen who provokes a fight through an unlawful assault would likewise be considered an aggressor. That's from John Rubin, The Law of Self-Defense in North Carolina. So basically, if you start it, you're going to have a hard time justifying it. And the context that springs to mind is the old cowboy movies, where the baddie provokes the poor sap to the point where he goes to draw his gun and the baddie shoots him dead. That would be a case of the aggressor provoking the situation that led to the deadly force. Now hopefully that's not something that's going to play out in the bars in North Carolina, but it's just an example that maybe helps make the point. Deadly force in defence of others. A citizen may intervene and use deadly force in defence of another person when, under the facts and circumstances, it reasonably appeared necessary to save the other person from an imminent threat of death, great bodily harm, or sexual assault, but only to the extent the other person was entitled to use deadly force in self-defence. Excessive force in defence of others is not allowed, and neither the intervener nor the person threatened can be an instigator voluntarily provoking the conflict for deadly force to be used. If you are not sure of the circumstances that initiated the action, it would be more prudent to contact a law enforcement agency or attempt to assist using less lethal means rather than immediately imposing the threat of deadly force. That's quite a mouthful, but I have it on good authority that in the event of an armed robbery of a cashier at a convenience store or a similar situation, that is the kind of situation where someone is in real imminent threat of death or serious bodily injury. That is the kind of situation where a concealed carry person may feel inclined to get involved. And that's something that we can discuss at the end of the video. Deadly force may not be used, A, to stop a simple assault. While a simple assault can be truly terrifying, the law only allows the victim to resist force with equivalent force. Force used to resist a simple assault must be proportionate to the assault. Even if a real and legitimate fear of greater injury, standing alone, does not justify use of deadly force. When does a simple assault become an imminent threat of death? When can a victim use deadly force to repel an unarmed attacker? The exact point in time a simple assault becomes aggravated or deadly in nature is often unclear. Repeated blows to vital body areas, choking, continued beating on a helpless or weakened victim are some indicators. I would say, because the law requires retreat from a simple assault, but does not require retreat from a murderous or felonious assault, an assault victim is once again faced with a decision. When does a simple assault become a murderous assault? No clear answer exists for the multitude of circumstances constituting an assault. So if someone slaps you in the back of the head or pokes you or does something that constitutes an assault but is not something that's likely to be inflicting serious harm, that's a situation where you would certainly not be justified in using deadly force, and most people should know that from a common sense viewpoint. Because of the use of violent language often leads to violent acts. But language alone does not justify deadly force. Just because someone says they're going to punch your face in does not mean they are ready and able to do so. Talk is cheap. Because you're a victim of past violence and fear future violence, the law requires that there be an imminent threat of death or great bodily harm. The threat must be immediate danger of death, not remote and uncertain in time and place. If the facts and circumstances are not reasonably apprehended as an immediate danger of death here and now, deadly force in self-defense is not allowed as a justified excuse for homicide. I would say that one you could consider in the context of domestic violence. Perhaps you're a battered wife and your husband, when he was drunk, when he was still living with you, whatever, was abusive, punched you, threatened you, inflicted serious bodily injury. And then you went and did your concealed carry course, got yourself a gun, and decided, I'm never going to let that happen again. Well, if he was to come back drunk, perhaps with a weapon, intending to inflict serious harm on you, and you shot him in self-defense, you would be covered under the law. But if you went and shot him while he was lying asleep in his bed, trying to preempt the situation, you're going to have a hard time justifying that under the law. So I think that past threat of violence should be clear enough in common sense terms. Because a trespasser refuses to leave, trespassers may be in violation of the law, but the law does not allow deadly force to end the trespass. While non-lethal force is allowed against a trespasser, deadly force is not. Old court cases establish a sequence for using force to eject trespassers. First, words must be used. Second, if words do not work, then gentle hands may be laid on the trespasser. If gentle hands do not work, the owner may use whatever force is necessary to remove the trespasser, but may not use force likely to kill or cause great bodily harm. The prohibition against using deadly force to expel a trespasser does not apply to a trespasser who is immediately threatening death, serious injury, or sexual assault. To arrest a criminal or prevent a criminal's escape. North Carolina law does not give the citizen the right to make a citizen's arrest. Since the power to make a citizen's arrest does not exist, The right to use deadly force to effect an arrest or prevent escape is not given to citizens. No matter how serious the crime, a citizen cannot shoot to stop a fleeing criminal. Citizens have a limited power to detain under North Carolina General Statute 15A-1404C. Now this one slightly had me wondering, so I looked up some additional material. This isn't included in the state materials, but I've added this in. Section 15A-404, detention of offenders by private persons. No arrest, detention permitted. No private person may arrest another person except as provided in General Statute 15A-405. A private person may detain another person as provided in this section when detention is permitted. A private person may detain another person when he has probable cause to believe that person detained has committed in his presence, and that's the important one, it must be actually in your presence, you can't do it after the event. 1, a felony. 2, a breach of the peace. 3, a crime involving physical injury to another person. Or 4, a crime involving theft or destruction of property. So they're the offences for which a citizen may detain someone, but it comes with strings and provisos. C, manner of detention. The detention must be in a reasonable manner considering the offence involved and the circumstances of the detention. D, the period of the detention. The detention may be no longer than the time required for the earliest of the following. 1, the determination that no offence has actually been committed. And 2, the surrender of the person detained to a law enforcement officer as provided in subsection E. E, surrender to officer. A private person who detains another must immediately notify a law enforcement officer and must, unless he releases the person earlier as required by subsection D, surrender the person detained to a law enforcement officer. Now, a typical example of this would be a store detective detaining a shoplifter. They then contact law enforcement, and when law enforcement arrives, they hand the person over to law enforcement. That would be an everyday occurrence. But if you walk in on an assault, if someone is assaulting someone else and you and some other citizens decide that it's a good idea to hold this person until the police get there, there is provision in the law for you to do that. But common sense rules typically apply, and the law in North Carolina, they clearly do not want you running around arresting other citizens. They would prefer that was left to law enforcement. But there is some coverage there for you if the situation does arise. Use of force to protect property. The law does not permit the use of deadly force solely to protect property, or to prevent theft, or to regain stolen property. An owner can defend his or her property using reasonable and necessary force, but not deadly force. Non-deadly force to regain possession of stolen property is lawful if it is both reasonable and necessary under the circumstances. An owner cannot, capitals, an owner cannot shoot at a thief before, during, or after a theft. The same rule prohibits deadly force to prevent injury or vandalism to property. A different rule applies if life is imminently threatened at the same time the property is taken. For example, an armed robbery is theft through use or threatened use of a deadly weapon. The victim is allowed to respond to the imminent threat to life of an armed robbery by using deadly force. Deadly force to prevent an armed robbery is force used to protect life, not to protect property. If only property is threatened, deadly force cannot be used. North Carolina does allow the use of defensive force up to and including deadly force against an individual who has unlawfully entered or is attempting to unlawfully enter a home, motor vehicle or workplace as discussed in the following lesson. So if you see someone in your car, they've hot-wired it or the keys are in it and they're going to drive off in it, you're not allowed to shoot them. You're not allowed to use deadly force to protect property, period. That's North Carolina law. North Carolina statutory law. All those previous sections were under what's known as common law. I'm not going to go into a long discussion on what common law is, but statutory law are those statutes that have been passed in the North Carolina Assembly. North Carolina statutory law. Home, workplace and motor vehicle protection. Presumption of fear of death or serious bodily harm. The lawful occupant of a home, motor vehicle or workplace, and I suppose if you live in an RV, that is your home, but it makes provision for you being in your workplace, so it gives you safeguards against being carjacked or other situations. The lawful occupant of a home, motor vehicle or workplace is presumed to have held a reasonable fear of imminent death or serious bodily harm to himself or herself or another when using defensive force that is intended or likely to cause death or serious bodily harm to another if both of the following apply. 1. The person against whom the defensive force was used was in the process of unlawfully and forcefully entering or had unlawfully and forcibly entered a home, motor vehicle or workplace, or if that person had removed or was attempting to remove another against that person's will from the home, motor vehicle or workplace. 2. The person who uses the defensive force knew or had reason to believe that unlawful and forcible act was occurring or had occurred. The citizen using deadly force under the statute does not have a duty to retreat prior to using deadly force. The way that's worded is a little bit interesting, but what I would read into it is if you're at home and someone enters your house and tries to kidnap a member of your family or someone who's in your household and they're trying to make off with them, that's a situation where you could justifiably use deadly force. That would be my interpretation of that. Section B, the last part being Section A. The presumption set forth in the above section shall be rebuttable and does not apply in any of the following circumstances. So here's the what ifs and the conditions. 1. The person against whom the defensive force is used has the right to be in or is a lawful resident of the home, motor vehicle or workplace, such as an owner or a lessee, and there is not an injunction for protection from domestic violence or a written pre-trial supervision order of no contact against that person. Number 2, the person sought to be removed from the home, motor vehicle or workplace is a child or grandchild or is otherwise in the lawful custody or under the lawful guardianship of the person against whom the defensive force is used. And 3, the person who uses defensive force is engaged in, attempting to escape from, or using the home, motor vehicle or workplace to further any criminal offence that involves the use or threat of physical force against any individual. That's a little more hard to process, but basically, if it's your nephew or your estranged husband or the person who owns the property or business, you're going to have a hard time justifying shooting them. If it's a stranger who's acting in a violent manner, that's a different story. So really the law tries to define common sense, but sometimes it's hard to cover every possible eventuality. Here's some more exceptions. 4. The person against whom the defensive force is used is a law enforcement officer or bail bondsman who enters or attempts to enter a home, motor vehicle or workplace in the lawful performance of his or her official duties, and the officer or bail bondsman identified himself or herself in accordance with any applicable law, or the person using force knew or reasonably should have known that the person entering or attempting to enter was a law enforcement officer or bail bondsman in the lawful performance of his or her official duties. Common sense should apply there. If the police are forcing entry to your premises for whatever reason, you don't have legal justification to shoot the police, provided they're acting in a lawful manner. Who decides when they're acting in a lawful manner? Probably not you. You have to assume that the police or bail bondsmen are acting in a lawful manner unless you've got some really compelling evidence that they're not. Number 5, the person against whom the defensive force is used, and bear in mind these are the rebuttable presumptions, these are the things that are going to be subject to scrutiny. Number 5, the person against whom the defensive force is used, A, has discontinued all efforts to unlawfully and forcefully enter the home, motor vehicle or workplace, and B, has exited the home, motor vehicle or workplace. So there's your other proviso. If someone's trying to break into your house, you produce a gun and say, if you come through that door, I actually had this experience. I had a guy banging on the glass door at the back of my house. I produced my Glock and told him that the moment he broke that window and tried to enter the house, I was going to shoot him. And discretion being the better part of valor, he decided that wasn't a good idea, and he stopped banging on the window and he moved away. Well, if someone's trying to enter your house and then they stop and they go to move away, that's where your justification for deadly force ends. Once the threat to you has ceased, you can't go outside and shoot them after the event. C. Self-defense and defense of others. 14-51.3 provides that a person is justified in the use of deadly force and does not have a duty to retreat in any place he or she has the lawful right to be, if he or she reasonably believes that such force is necessary to prevent imminent death or great bodily harm to themselves or another. A citizen who lawfully uses defensive force in compliance with these statutes is immune from civil and criminal liability. That is huge. If you act according to the law, you cannot be sued and you will not go to jail. Therefore, it is worth your while knowing what the law actually says. The justification described in North Carolina General Statutes 14-51.2 and 14-51.3 is not available to a person who used defensive force and who, 1, was attempting to committing or escaping after the commission of a felony, 2, initially provokes the use of force against himself or herself. However, the person who initially provokes the use of force against himself or herself will be justified if either of the following occur. A, the force used by the person who is provoked is so serious that the person using defensive force reasonably believes that he or she was in imminent danger of death or serious bodily harm. The person using defensive force had no reasonable means to retreat, and the use of force which is likely to cause death or serious bodily harm to the person who is provoked was the only way to escape the danger. B, the person who used defensive force withdraws in good faith from physical contact with the person who was provoked, and then indicates clearly that he or she desires to withdraw and terminate the use of force, but the person who is provoked continues or resumes the use of force. That's all a little convoluted, but basically if you start the fight and the other person is going to kill you, the onus is on you to disengage and try and resolve it unless there's no other way around it. So I suppose back to the road rage scenario. If you're in a situation with someone and you vent off at them for their bad driving or for some other behaviour, perhaps in Walmart if someone's cut the queue or some other thing, and then that person comes at you with some such disproportionate amount of force that you're put in fear for your life, only in a case like that where you have no other options are you justified to use deadly force. So these are the sort of scenarios that I would have to tell you, you're probably better trying to avoid those situations in the first place. But that's my opinion, based on quite a few years of experience and seeing people do stupid things. Section D, storage to protect minors, North Carolina General Statute 14-315-1. Any person who resides in the same premises as a minor, defined as a person under the age of 18 years, who owns or possesses a firearm, and stores or leaves the firearm in a condition that the firearm can be discharged and in a manner that the person knew or should have known that an unsupervised minor would be able to get access to the firearm, is guilty of a Class 1 misdemeanor if the minor gains access to the firearm without the lawful permission of the minor's parents or a person having charge of the minor, and the minor, 1, possesses it in violation of North Carolina General Statute 14-269.2b, which is unlawful to possess firearm on any educational property, public or private of any kind. 2, exhibits it in a public place in a dangerous, angry or threatening manner. 3, causes personal injury or death with it, not in self-defense. Or 4, uses it in commission of a crime. So if you have your gun in your bedside drawer, your nightstand, and someone under the age of 18 gets access to it and commits any of these things, takes it to school for show and tell, exhibits it in a public place in a careless, angry or threatening manner, causes personal injury or death with it, not in self-defense, or uses it in the commission of a crime, you are guilty of a Class 1 misdemeanor for letting that happen. That's one part of it. Now the other part is Section E, permitting young children to use dangerous firearms. That's under North Carolina General Statute 14-316. It shall be unlawful for any person to knowingly permit a child under 12 years of age to have access or possession, custody or use in any manner whatsoever of any gun, pistol or other dangerous firearm, whether such weapon be loaded or unloaded, unless the person has the permission of the child's parent or guardian and the child is under the supervision of an adult. Any person violating the provisions of this section shall be guilty of a Class 2 misdemeanor. So basically, if a child is under 12, you can take your child or someone else's child, if that child's parent or guardian permits, you can take them shooting under supervision. From their 12 until they're 18, you can let them use a gun in normal circumstances. In fact, they can use it for home defense if the situation demands that. But the onus is on you to make sure your guns are secured and that nobody can get unauthorized access, and that's the law in North Carolina. The other thing is common sense. You do not want a very small child to get their hands on a loaded firearm. That is a tragedy waiting to happen. You do not want that on your conscience, never mind what the law says. So common sense should apply, but as the wise Mark Twain once said, common sense ain't always that common. Concealed carry handgun, North Carolina General Statute 14-415-10. The definition of a handgun. Try and remember this, because it just might come up in your exam, I'm just saying, you know. A handgun is defined as a firearm that has a short stock and is designed to be held and fired by the use of a single hand. The definition of a handgun has two characteristics in this statute. First, the firearm must have a short stock. Second, the firearm must be designed to be held and fired by the use of a single hand. Revolvers and semi-automatic pistols are treated alike. Caliber of the firearm is not specified. While length or configuration of the firearm stock is not defined, presumably it must be shorter than a standard rifle or shotgun. A judge might reasonably conclude that a standard rifle or shotgun is not designed to be held and fired with one hand, even if the rifle or shotgun has been cut down so it can in fact be so held and fired. Federal and state firearms law prohibits possession of a sawed-off shotgun or rifle. This law applies only to handguns. No other types of weapons, e.g. clubs, knives, or martial arts weapons, are within this definition. Now that's a point worth knowing. North Carolina concealed carry provision relates only to handguns, and in practical terms, we are probably talking about a regular pistol, either a revolver or a semi-automatic, and not a rifle that has been made into a pistol. Now you can get a pistol AR or a pistol AK-47, but they are not pistols in the normal sense of a concealed carry gun. You're not going to find a holster to fit them. You're not going to be able to conceal it unless you're wearing a trench coat. So for practical purposes, a pistol version of a rifle isn't really going to be a pistol as far as concealed carry is concerned. Concealment defined. The statute further requires the concealed weapon be about the person, which generally means it must be concealed either on the person or within an arm's reach or within ready access of the person. That factors in when you're in a vehicle. You can have your concealed carry permit and your concealed carry handgun in a vehicle where you can readily access it. For that, you need a concealed carry permit. If you do not have a concealed carry permit, you may not have a readily accessible handgun in your vehicle. You can have it in the trunk where it's not readily accessible, that's fine. But one of the privileges of a concealed carry permit is that you can have the gun convenient in your vehicle. Required documentation. The permit issued to carry a concealed handgun must be in the possession of the permit holder at all times the person is carrying a concealed handgun. Do not leave the house with your concealed handgun if you do not have your concealed carry permit with you. In addition, the statute in North Carolina General Statute 14-415-11A also requires possession of valid identification which is not defined. In practical terms, that's your driving license for most people. If you don't have a driving license, you'll have an identity card. Either of those would be acceptable to law enforcement. Passport is not something that everybody has, and it's not state issued, it's a federal document. But you must have your concealed carry permit, which is credit card size, and valid identification. Note again that carrying a concealed handgun off one's own premises is not lawful unless both the actual permit and a second form of identification are also possessed at the time. That's the law, black and white. Places where the permit does not authorize carrying a concealed handgun. This actually will be covered later in the presentation. What to do if approached by a law enforcement officer. Firstly, do not attempt to display the handgun If your handgun's concealed, keep it concealed. Don't make a drama about it. If you're in a vehicle, roll the window halfway down. At night, turn on the interior light. Place both hands on the steering wheel. Some people, in anticipation, if they've been pulled over, they've got the blue flashing lights. A lot of people will get their wallet out and ready and set it up on the dash where the officer can see it before he reaches your vehicle, and that would be sound advice. Once the officer approaches the vehicle, notify the officer that you have a permit, that you have a weapon in the vehicle, and tell them where it is. Often they will ask you where it is. In my case, typically it's in the center console. Do not attempt to display the handgun, and keep your hands where the officer can see them. Times are extremely tense at the moment. You do not want to be doing anything around a law enforcement officer that's going to cause him stress and perhaps provoke him into killing you. And sadly, it's the situation that we live in. So the onus is on you to work with the police to make sure that neither of you come to any harm. Only attempt to remove the permit or the handgun on instructions from the officer. I would go further than that, and this is based on what I was told in Salemburg. If the officer wants to see license and registration, and you already have it out on the dash, or you tell him, my wallet is here, I am reaching for my wallet now, or whatever, make sure that you're on the same page. Make sure that there's no miscommunication. What I was told in Salemburg was, if the officer tells you to hand him the gun, don't do it. Say, sir, I'm prepared to get out of my vehicle, step aside and let you recover the handgun, but I do not wish to handle the firearm in your presence. And just flatly refuse to do it. What's he going to do? If he wants to see your gun, if he wants to put hands on it, let him. But don't pick the gun up. Do not be the person who picks up the gun in front of a police officer. That could end badly for you. Next part is escalation of force. And just to see how much material we have left, it's quite a bit. This is going to wind up the first part of lesson 1. I don't want to go beyond 45 minutes in time. I will do a lesson 2 so that we can do the rest of the law. The law is the biggest part of the concealed carry course, and it will take at least a solid 2 hours to get through it. So we're winding up at this point between what to do if approached by a law enforcement officer, and we will pick up again at escalation of force.